Welcome to Beyond the Numbers, the podcast where conversations about wealth go deeper. This isn't about flashy success or one-size-fits-all advice. It's about real people designing financial lives that align with who they are, what they value, and the legacies they're building. We bring together voices from business, finance, law, and leadership to talk about the moments that shape them and the strategies that sustain them. Here is your host, Chris Everett.
Well, welcome everyone to Beyond the Numbers, where money meets meaning and purpose. Today, my guest is an attorney, and he has been transforming how people think about estate planning for over the last 20 years. He holds an MBA, a JD, and has earned the prestigious Accredited Estate Planner, or AEP designation, from the National Association of Estate Planners and Counsels. He specializes in estate planning, taxation, Medicaid planning, special needs planning, and corporate governance. But, here's what really makes him different from other attorneys. When you sit in a room with him and he's explaining complex legal concepts to clients, it's like watching a master teacher who just clearly explains everything crystal clear in everyday language. And these are complicated trust and tax strategies. So you're not going to hear legal jargon. No trying to sound smarter than everybody else in the room. Although, I tell you, he's really smart. He just brings real people solutions. So, or solutions to real people, I should say. So with all of that, please welcome Robert Mondo of the law offices of Robert J. Mondo. Welcome to Beyond the Numbers, Bob.
Thank you, Chris, very much for inviting me on this. I'm excited to do this, and hopefully we can provide a whole lot of good information to not only your clients, but other people that are interested in this type of thing.
Oh, listen, absolutely. And if you don't provide all that value, you're in trouble.
Shame on me is right.
All right, so look, Bob, tell me about your practice and what gets you most excited about the work that you're doing.
So, I'm a sole practitioner and have been doing federal tax and estate planning for, about 26 years now.
Mm-hmm.
And I started out just as a tax attorney. And it's kind of a long story how I got into estate planning, but it just kind of morphed into that type of practice. And like I said, I do federal tax work, estate planning, a little corporate governance. And I do understand other types of law, but those are the two things, federal tax and estate planning, that I concentrate in. Can't say you specialize because that's against the rules, but I concentrate in those areas and that types of. And I have been kind of shutting down and not doing as much tax work lately because it's getting more and more tedious. So I don't do any offering compromises anymore, deduction disallowances or revenue rulings, criminal tax work, audit representations. I primarily focus on helping individuals and families with their estate planning. And that gets me excited. Even after 26 years, I still like doing it.
Yeah, that gets me excited too, because you've worked with a lot of my clients and I get unsolicited praise about your estate planning work all the time, which is pretty cool.
So it's all about, it's all about them,
Mhm.
right? It's about them, educating them, like you said, educating them, making them feel comfortable, not only with just the concepts, but also the procedure on things. And then what I really like is all of a sudden they just kind of nod their head a little bit and they say, "Yeah, I get this. This is no big deal. This is good stuff." And as soon as I get that kind of buy-in, that's when I know it makes me happy, because I can explain things to people all day long, and if they don't understand the concepts, number one, my fault. And then number two, it doesn't go anywhere, because I look at myself almost like an educator instead of being an attorney. I educate people on these things, and then they make up their minds and decisions as to how they want to move forward. Obviously with my advice, but and I try to guide them, but I'm not presumptuous with certain things, even though I do tell people, I already know what you need. I already know what you want, which is really presumptuous. But we all kind of have the same goals about estate planning. And so those are the things that get me up in the morning to be able to do those types of things.
I mean, generally, I think most people want the same things. But, when we had spoken before, You had talked about things like intentionally defective grantor trusts or special needs trusts or domestic asset protection trusts. And these sound complicated, but I know you have a gift for making those complex things simple. So, can you break down what those actually are?
Well, sure. So, uh, one of the let me back up a little bit. Some of the biggest mistakes that people make is they go to an attorney that really does not concentrate in this type of law.
Oh, thank you.
What a very, very high percentage of attorneys do is they do all kinds of stuff. They do real estate, they do divorce, they do X, Y, Z, and whatever, and then they dabble in estate planning work. And they buy a word processing program that they pay, I don't know, a certain amount of money for every single month. They meet with people, they type the information into the computer, it spits the documents out. A lot of the attorneys, number one, don't really know what it does. Number two, what it says, or what the process to make these things work are. And so those are form documents.
Well, how do you
The
know
other
that?
thing,
How do you know that these other attorneys aren't as smarter or really doing the right job?
well, people bring me their trust all the time. I just had a couple bring me their trust from 1996.
Oh, my
Those
Lord.
were wealth council documents. I as soon as I see them, I know. So there's wealth council, there's elder docs, and then there's legal docs. Those are the main ones. Now you've got online services, will and trust and whatnot that are very formulaic, and people try to do things using ChatGPT.
Mhm.
It's just not as effective as using an attorney like myself that over the course of about 10 years with a number of other attorney friends of mine, we put together our own estate planning documents that deal with all kinds of things that those form documents don't deal with. Tax issues, creditor issues, addiction issues, making sure that assets go to the people tax-free, creditor-free, et cetera, et cetera. But there's and like you brought it up, there's a number of different vehicles that you can use to accomplish a whole lot of goals. And so kind of the basic estate plan is a revocable trust, whether it be a single or a family trust.
Mhm.
I do not use what are called reciprocal spousal trusts,
Explain
which
that. Yeah.
okay, so reciprocal spousal trust is where both spouse have separate trusts.
Mhm.
Husband has a trust, wife has a trust. And prior to 2012, there was not this legislation called portability. Prior to 2012, if you did not have these reciprocal spousal trusts, or if you did not have a family bypass trust, the first spouse to pass away, that person's a federal estate exemption and state estate exemption would be lost.
Mhm.
In 2012, there was legislation that was enacted that says that if you pass away in the last day of your life and you are married, that portability, I'm sorry, that the portability stays in place and your exemption is not lost. So what reciprocal spousal trust did was each trust had its own estate exemption. But the problems with those are titling, which you know, Chris, is you cannot title the same asset in two separate trusts. It's
Right.
got to pick one. So what attorneys would try to do is they would try to do 50-50 between the two and balance those out, which can be difficult. The other issue is that a lot of those reciprocal spousal trusts, if one spouse passes away, that trust is irrevocable. And what that means is it's held irrevocably for the beneficiaries, which are normally the kids.
Mhm.
The surviving spouse only has access to 5% of the principal. Sometimes it's 10, but normally it's 5% of the principal of that irrevocable trust. They get all the interest and everything. They can only invade. So now what happens if they have to liquidate something because they've got to pay a bill? They can't do it. Then the other issue is that there's tax issues. So I'm going to make this up. So let's say my wife and I had reciprocal spousal trusts. Could only put the house in one trust. Some attorneys try to do this thing, which is a legal fiction, which I can't understand, which says that 50% of an undivided interest goes in each trust. And I challenge anybody to define what a 50% undivided interest is, because I can't figure it out. Anyways,
That is
so
crazy language. Yeah.
it is. And so let's say we bought our house, I don't know, 40 years ago for $200,000. So then we put it in my trust only. I die. Let's say then upon my death, there has to be an appraisal of the house. Let's say it's worth $400,000. Then my wife lives in the house for the next, 40 years or so. And now the house is worth $700,000. Well, the first $400,000 goes, and then my sons take it. They inherited it. And then they sell it for that $700,000. The first $400,000 is what is called a return on cost basis.
Mhm.
So there's no taxes on that. The next $300,000 is taxable at ordinary income and capital gains, because there's a step up in basis to my death as the grantor. So there's tax issues with those reciprocal spousal trusts. My friends and I saw this immediately, being tax attorneys. And so what we did is we have a family bypass trust, which then doubles the estate exemption. You only have one trust in which to title it in. There's really no access issues. And there's a step up in basis to the second person to pass away. So in my scenario, if we bought our house for $200,000 and my wife passed away and it was worth $700,000, my sons inherit it. They sell it for $700,000. There's no tax.
Yeah. I can't tell you how many times I would meet with clients after doing this trust work before 2012, and we were always doing the balancing act. Okay, what assets are here? What's that value? What's this value? And it was crazy making. So this
Yeah,
is really a blessing.
it's cumbersome, is
Yeah.
really what it is. And here's the thing, falls squarely on your shoulders. Let's
It
be honest,
does. Yeah,
right?
it does.
And which we're going to talk about the synergies between the attorney and the financial planner, which is utmost importance. So, but anyways, okay. So a basic estate plan includes a trust, whether it be single or family. And we have 7 different categories of estate planning that we have put together.
Mhm.
Most of those word processing programs, there's 2. You're single or you're married, that's it. We have 7, and they're specific to that person's marital situation, the age of the children, et cetera, et cetera.
You know what you're really saying, but I'm sorry to interrupt, but I really, really need people to hear this part because I am not an attorney, but I'm pretty smart. I know how to read. So when I look at some of these trusts, I'm thinking, oh my Lord, they have no idea. Or they're very old, right? And they really need updating anyway. And so
Yeah.
the difference that you're making right now, I don't want this to go unnoticed. If your trust is older than 2012, please see an attorney who knows what they're talking about. For
Yes.
sure.
Or if you have those reciprocal spousal trusts,
Right.
yes, go see an attorney and talk them into doing a family trust for you. So, all right. So what a family trust or a regular revocable trust does is it avoids probate. It makes sure that the grantors, those that are setting it up, are taken care of in time in case they're ever incapacitated. It makes sure that the secondary beneficiaries get the assets tax-free, creditor-free, addiction-free, at the highest value available without any judicial oversight or any court supervision or without any outside influences. So it directs it, it keeps it in the family. And there's legacy planning that goes into it as it relates to if in fact a beneficiary passes away, then it needs to go to the next generation. There's all these things that it allows to do. And those types of trust, those are the most prevalent, and that's what everybody that either has $150,000, because the state of Illinois just bumped up the small estate affidavit from $100,000 threshold to 150 just this week, as real estate, because real estate always subject to probate unless it's in a trust or an LLC or another thing called a transfer on death instrument, which has its own problems, which I never do. And if you've got kids, any of that 3 combination, somebody should do an estate plan. So, and then you started talking about different types of trusts. So there are asset protection trusts. There's domestic asset protection trust, and then there's foreign asset protection trust. The most prevalent domestic asset protection trusts are based in 4 different states: South Dakota, Alaska, Nevada, and Delaware. And they have certain statutes that allow them to provide this asset protection as long as the person setting up the trust, the grantor, transfers all of that person's assets into an irrevocable trust with a trustee that is domiciled in one of those 4 states. So I only write those types of trusts for people that are inherently dangerous businesses, those people that get sued all the time. Certain types of doctors, civil engineers, people that own coal mines, people that are airplane mechanic, those people get sued all the time. Okay, so I only do those for them. But those domestic asset protection trusts, they're very disruptive because you actually give up constructive and legal title of your assets to whoever the trustee is. So you don't own your assets. And it's kind of a little bit of a sleight of hand. And it's always, it kind of bothers me sometimes because for the simple fact is somebody gets sued, I don't own anything. Go ahead and get your judgment. You don't even have to defend yourself because they can't they can't attach or they can't seize or they can't lien your assets. So that's I don't do those very often. Now, special needs planning, self-settled special needs trusts, third-party special needs trusts for children or adults that have some type of a diagnosis that prevents them from fully developing. And if in fact they are entitled to any state or federal aid or any type of benefits, Medicaid, Social Security income, Social Security disability, there's all these other types of things. We also do another irrevocable trust that separates the assets from the child or the beneficiary, so that if in fact they have assets that are in excess of a certain threshold, it doesn't make them ineligible for those state or federal benefits. And that is an important type of planning. So you've got your regular trust, and then or any type of revocable trust, and then a beneficiary of that revocable trust is a special needs trust, or one of the beneficiaries is a special needs trust. Because what I see a lot of is somebody that has special needs, they leave the monies directly to that person that has the special needs, and it allows them no supervision. It makes them ineligible for any type of, again, state or federal aid. And it's counterintuitive to give somebody that has a special needs all this money, even if they're high functioning. Sometimes high functioning don't do as well. So special needs planning, very, very important.
Essential. Absolutely.
Essential,
Mhm.
exactly. Then there are grantor retained annuity trusts, charitable remainder trusts, but the one that is becoming more and more prevalent that I write mostly is what are called intentionally defective grantor trusts. All right, what's that? No, it's not defective. It's just a little bit different. The reason it's called that is all irrevocable trusts, except for the IDGIT, intentionally defective grantor trust, have their own tax ID. Special needs trust, domestic asset protection trust, they all get their own separate tax ID. Because if you have a separate tax ID for something, it's considered to be a separate person under the eyes of the law. Now, what an intentionally defective grantor trust is, it's for wealthy people. So I met with some people today. I'm going to do a family bypass trust for them, which means the first $8 million under the state of Illinois is covered for them. They pass away, it goes to their 2 children tax-free.
Mhm.
Anything over $8 million to $30 million is taxable to the state by the state of Illinois, starting at about 16% and then graduating up to 20%. So let's just call it 20%. And they had about $18 million in assets. So that means they've got upon their passing, there's a $10 million potential estate tax that would be assessed to them by just the state of Illinois, which means at 20%, that's a $2 million tax bill
Mhm.
right then and there. So what an intentionally defective grantor trust does is it removes that extra money over that $8 million, the $10 million from their estate, and it transfers to the trustee of the intentionally defective grantor trust. And the way that it transfers is we open up a new account, but then for the value of that account, the trustee of the IDGIT, it secures a promissory note in favor of the grantors, those people that are transferring their assets to the trustee in that exact amount. So in this case, $10 million. So that transfer, there's been no money that is passed along. So it's a tax-free transfer. Now, those monies are not really considered to be the grantors. They're owned by the trustee. And what makes the idjit defective is that it does not get its own tax ID. So we use the grantor's social security number for the tax ID, which means the grantors have the ability to pay the taxes on any income or growth. And what that then does is that increases the basis of the monies in the brokerage account or the LLCs or whatever they may be that are titled into the intentionally defective grantor trust. And so those stay separate, even though it doesn't have its own tax ID. Now, let's say the clients that I have today, let's say they want to buy $1 million yacht. They call up the trustee or they are requested in writing, hey, send us $1 million. Now that promissory note is not worth $10 million. It is now worth $9 million. And any interest that is accrued on that $9 million or that $1 million is taxable to them at the end of the year as a part of the promissory note. So with the big, beautiful bill going from whatever it was, 13 point something per person to now 15 million and 30 million, then I do have clients that have more than $30 million, but those people that have more than $8 million, there's a tax, an Illinois state tax that would be assessed to them. So it is a tax saving vehicle. And yes, it is a complicated document, but what it does is exactly what I said. It removes the assets from that person's estate so that any taxing entity can't touch it.
Yeah, I mean, it's actually pretty simple if you diagram it out, right?
Yeah, which I think I did in the office one
Yeah,
day.
it's like, here's my money, give me a promissory note.
Right, exactly.
Um,
And then the other good thing about it is the grantors can direct the trustee as to what the investments are.
which is really beautiful, right? It really escapes a lot of taxation. You still have a lot of control over it. It's a beautiful document.
Correct. Yes.
Okay, so do you think you could walk me through a recent case where estate planning and financial planning had to work seamlessly together?
Sure. Just this case I did a few weeks ago. It was a family, and it was a very wealthy family. I won't give you the numbers, but it was considerably more than $30 million. And they had a couple of current financial planners. Financial planners said, call Bob Mondo. You've got some potential tax issues here. And so what I did was I created that family bypass trust. I created that intentionally defective grantor trust, and then sent it to the financial planners. Now, the financial planners' job, and they did most of the heavy lifting. They then have to take the existing investments and transfer them into the intentionally defective grantor trust. And it's setting it up. I personally would never be able to do that. I'm not a financial planner. I don't know the ins and outs of what to do. Chris, you would have no problem doing it.
Oh, we have a
One of the
department. Yeah.
things that I'm sorry.
I was going to say, we have a department to handle
Yes.
all of that, so it gets done.
Right. So it's hand in glove, you and I. And so the process is I prepare the documents, I give the advice, this is what we should do structurally, and then you as the financial planner, you act on that structure and you make those assets grow. Is really what you do. But the first thing that we had to do was we had to retitle a bunch of different brokerage accounts and LLCs into the idjit. And so there was a lot of concern, and it was a big custodian that did this, and they didn't understand. I had to explain it to them that it is a like-kind exchange because those old brokerage accounts, as well as the idjit, still use the same grantor social security numbers. So it's it's a like-kind exchange. Not a 1031 exchange, it's an in-kind exchange. So there was no liquidation of assets. There was no capital gains. The investments went from this to that with no impact.
Yeah, easy breezy. Do you ever run into challenges between estate planning and financial planning mindsets?
No, because we're doing the right thing. It's all about the client's well-being. And I really don't get any pushback. Oh, we're doing it wrong. No, I don't get those. I get these. What do you think we should do with this?
Yeah, that's good.
I'll tell you, one of the challenging ones is I had a client of mine, great guy, I love him. I miss him to this day. And he passed away, I want to say in November of last year. I did his estate planning. He did not disclose to me that he had all these assets. He owned several buildings and all these financial assets. Great guy, but very tight-lipped on those things.
Yeah.
Well, I just did a regular old revocable trust for him. Well, it turns out that he was still married and he had about $17 million worth of assets,
What a missed opportunity.
right? And so here's what happened. He named his 3 sons as the beneficiaries on his revocable trust. And I knew if we were going to do it this way, they were going to, a big chunk of it, $13 million is going to be taxed at about 20% plus the feds, right? So you got the feds at 13 point something. So there was a federal tax bill there of 40% of whatever it is, because the feds give you dollar for dollar credit for any state, or the state gives, the opposite way. So I came up with a plan, and I told the 3 boys, I said, here's what we need to do. You guys need to waive your rights to all of the assets. And because in the trust that I write, if there's no beneficiaries left, it follows what is called intestate succession. In intestate, it means that somebody passed away without a will.
Mm-hmm.
And succession means, well, you know what succession means, who gets it. And so what that legislation determines is if there is a surviving spouse, all of the assets go to that surviving spouse. All of it, 100%.
And that was this person's intention, wasn't it?
No, it was not.
Oh.
It was all wanted to go to the boys. They had been separated for a long time,
Okay.
not living together or whatever, but they never got divorced. So I was cognizant of this, and I said, this is what you guys need to do. You're going to buy yourself maybe a $3 or $4 million tax bill if you don't do what I tell you to do. Waive your rights to the assets. Have them all go to your mother. They took some money out, not a whole lot, maybe $500,000 a piece. All right. Waive your rights to whatever the remainder was. It all goes to your mother. I did the mom's estate planning, and then I did that intentionally defective grantor trust. So she has about $3.5 million in her family trust, her individual trust, and the rest of it, except for what the boys took, is in her idjit. So eventually, when the mom passes away, those assets go to the boys tax-free.
Yeah, beautiful. Beautiful.
So jumping through hoops, Chris, just it's one of those things. You don't want to have to do that. Now, if he was honest with me, I wouldn't have to done all this extra work and this planning.
Mm-hmm.
So that's the other thing that a financial planner really helps out with is they know, or they should know, what the value of somebody's estate is.
Oh, yeah. Oh, yeah.
I would have no idea. I just have to trust what they tell me.
Mm-hmm. So you mentioned earlier that the Illinois estate or small estate valuation went from 100 to 150. What other things are happening in the tax law now or in estate planning right now that my audience should know about?
Well, Big Beautiful Bill went from 15 million per person for a married couple, 15 million to 30 million. It was 13 point something. But there's a misunderstanding about that. That is supposed to sunset at the end of 2025. That's not going to be permanent. Also, the tax brackets have come down. The individual tax brackets have come down.
Mm-hmm.
And certain exemptions have gone up, and credits and the SALT and everything else has all been increased. But those are something that anybody can read on the internet, the Big Beautiful Bill, and become an internet intellectual when it comes to that. But as it relates to estate planning, it's kind of the same stuff.
Yeah.
Just different numbers.
Well, and also taking advantage of all these exemptions means you're saving a whole lot of money and
Right.
heartache and headache, right?
Right. Well, I don't prepare returns anymore, so that's more for somebody an accountant or something.
Yeah, of course.
Along those.
So you mentioned you worked as a solo practitioner, but you've got a succession plan in place. Tell us about that.
So in Illinois, anybody that is a sole practitioner of any sort has to have a succession plan, which means you have to have an agreement with another firm. So if something happens to me, my clients get a letter. Here's what it says, Chris. Bob is dead. Call us. And that firm I have is in Wheaton. It's a big firm by the name of Marquardt and Belmonte, and it could change from time to time because I've had other ones, but right now they're the best of the bunch. And so anybody that has a sole practitioner, they have to ask them, do you have a succession plan? If they say yes, you're in good shape. They say no, maybe you probably shouldn't want to do business with that attorney. Okay. So, but that's Illinois attorney requirements.
Okay. I look at my clientele who come and we look at everything in their life that has a dollar sign connected to it, good, bad, or whatever ugly might be there. And like you said, I have to assess the valuation of everything, not only what they want to do. But one of the things that we've put in our practice, because you talked about working with a financial planner and how important it is to really work together to make everything gets funded properly. So what I've learned over the years is if it's part of my process, it tends to get done. Okay. And so we have a checklist. And every time someone comes through the practice and we do a financial plan, a retirement plan, whatever it might be, we always make sure the documents are current. And if they're not sure if they're right or wrong, then obviously we get a second opinion. But more importantly, I always have these check valves along the way so that if they didn't if they did the trust, it also gets funded as well. Just had a couple of people just in the last couple of months who I'd said, "Okay, you went and you saw Bob or you saw your attorney. Now let's make sure everything gets funded." Oh, yeah, we forgot about that. So it must become part of a fiduciary's process to ask about it, to inquire, almost to take ownership of it. I know it's really the clients that must own it, but if clients don't do this every day, they don't do it every day and they need someone to step in. So that's where I see my office being functional when it comes to working with attorneys like yourself.
Yeah, it's a team approach.
It really is.
It is. It's so when I get a referral from your office, I love it because I know it's going to be an easy thing for us to do because you've got a crack staff that already knows
Yeah.
virtually what to do.
Yeah, they're
What to do
awesome.
with beneficiary assets, what to do with non-beneficiary assets, and how to communicate.
Well, and
So,
they've done their own planning, and so they get it. They've gone through the process, and so when
right.
I ask them to hold someone else's hand through the process, they understand how important it is and how it's
Yes.
done.
Yeah, and I've done most of the people in your office there too, so
Mhm.
that they understand what goes on. But what I do too is when I provide information, the first page of the binder talks about this is what I did for you, and this is trust funding. Then inside some introductory information, there's a chart that talks about trust funding, beneficiary assets, non-beneficiary assets. Anytime I explain an estate plan of any sort to anybody, a large portion of that explanation is surrounding trust funding. Then a couple of weeks after I send them the documents, I send them a letter, a reminder letter. Remember to do this. And it is a checklist of things. And I send those periodically too. It's not just a one time thing. I send them a couple times a year to those clients because trust funding is, in my opinion, as if not more important than having those documents in place.
No.
Because trust funding and funding of things of an estate also includes beneficiary designations as well. It's just not putting things into trust.
Right.
There's designation there. It's more to it than just transferring title into trust or adding a there's a holistic approach to it. And like just what that one that I told you about where he wasn't completely honest with me, we're still digging it out. He had no financial planners. He had nobody. If he would have had a financial planner, I would have talked to that person and with obviously with his permission.
Yeah.
And we wouldn't still almost a year later be digging out of this mess.
Yeah, or in my practice, from time to time, we'll get calls where someone's on their deathbed and the trust work isn't done.
Right.
Um, so
Hmm.
yeah. For the best result, first consult, as a friend of mine used to always say. So I know that you have a great story about how you put all this knowledge together. Something about how when you went through law school and had epiphanies. Tell my audience who you really
So
are.
All right. Well, when I went to law school, I went at night. So I worked during the day and I drove into the city at night. And night school is a little bit different than day school. Day school, it's younger kids.
Mhm.
Night students are more mature, working. Some have children, families, and whatnot. And so they treat us differently. And so if you remember, Chris, when you went to school, you had to take certain classes that you weren't interested in, like one I use all the time, biology. You're not going to be a biologist, but they make you take
Hey, I was
biology.
gonna be a doctor. I loved biology.
All right, well, bad example. Okay, uh, Tibetan philosophy. All right, how about something like that? Anyways, okay, same thing in law school. So when you go to law school, they make you take those basic classes, and everybody has to take them. And then at the night school, there was maybe 40 or so of us in the class.
Mhm.
And once you get through those basic classes, what you do is you pick the classes in which you're going to pursue later as your career. I was just going to be a tax attorney. So in those basic classes, were maybe 40 of us or so. In those tax classes, there was 6 of us because not too many people want to have want to be tax attorneys. It's very tedious. It's not glamorous in any way. And you have to have certain types of degrees before you can be a tax attorney. You just can't say, I'm a tax attorney. It doesn't work
Mhm.
that way.
Mhm.
So we recognized this and we knew we were going to go through school taking the same classes. So we picked our classes, went from class to class to class together, study together. Everybody graduates, everybody goes to their different jurisdictions, everybody passes the bar. And we recognize that federal tax law is no different in any jurisdiction, whether you live in Texas or Illinois or well, it's federal, right?
Mhm.
So what we did is back in the day before Zoom and meetings and the whole thing, and before the internet for the most part, we would have a conference call. And we every Saturday morning, 10 o'clock Central Standard Time, where we would discuss the different cases we had seen the week before, revenue rulings, criminal regulation changes, commissioner letters, all kinds of things, just to stay on top of this stuff
Mhm.
because tax law is very expansive. I don't know if you've seen an Internal Revenue Code book lately; it's about like this big, um, and it's ever changing. Now we just go online and I can look anything up,
Mhm.
right? So, but back then to do it, we put this little support group together. Well, a couple of years in, one of the guys says, "Hey, we should look at this estate planning stuff." And we were kind of like laughing at him, like, "Why would we want to do that? I mean, we're the top of the heap. We're the, I don't know, we're the emperors. That's for like a jester or something. Like that's a terrible analogy. But anyways, he, some tax attorneys are pretty arrogant. I'm not. I know my place. And he persisted, and what we did was
First of all,
is
I'm
we
supposed to say you're not arrogant, not you. But
well, that's true.
let me just underscore, you are not arrogant.
Okay, good. I appreciate that very much. So, so what we did is we took on the project of putting together our own estate planning documents. And it took us about 10 years of using best practices from all these different jurisdictions to come up with 7 different categories of estate planning. And each one is different. There's similarities, but they're different. So category 1 is you're single, no kids. Category 2 is you're single, minor children. Category 3 is you're single adult secondary beneficiaries. Category 4 is you're married, minor children. Category 5 is you're married, adult secondary beneficiaries. Category 6, you're married, no children. Category 7 is any of the below with a special needs child or children.
Mhm.
And we fit those into specific categories, and it's a little bit different. Like those attorneys that use that word processing program, they type that stuff in, it spits the documents out. They have no they can edit it, but they won't do it. With ours, the way that we put it together is we have color-coded provisions based upon the category. What I do is I marry those color-coded provisions into another document that ends up being the trust and the
Mhm.
supplemental trust documents. So it's specific to each client.
As it should
So
be. Yeah.
and we've got to copyright it and everything else. And it's kind of funny. So under the Illinois Trust Act, if somebody passes away, a beneficiary is entitled to receive an entire copy of a trust or a mistake or a will within 60 days of the person that makes the document passing. So I will send out trusts to all of the different beneficiaries, and I'll get the call, and hi Bob, this is so and so. I work with so and so, and I'll get the question, where did you get this trust? First question. Then I'll say, what do you use? Elder docs, wealth counsel, legal docs? What do you use? Yeah, how did you know that? Because it's that different. And so then I'll explain things to them, and then they'll ask me, can I get a copy of this? And I always tell them, you have a copy of it right in front of you. They want it in Word because they want to
Manipulate it. Yeah.
they want to manipulate it, and they want to steal it. And I tell them there's 7 different categories, so the one that you have isn't for everybody.
Right.
So that's one of the things that we have set up so that we've got proprietary documents that accomplish all kinds of good stuff.
Well, you kind of just roll right into my next question then, partially. So if someone's listening and they're thinking about doing their own estate planning, what are the key things that they should be looking for in an attorney?
Okay, well, number 1 is do not try to do it yourself. Do not go online. Do not sign on to one of those services. For the simple fact is, you on your own, I don't want to say this, very difficult to do because there's more than just a trust that goes into an estate plan. The things that you will look for in finding a good attorney is an attorney that concentrates in tax and estate planning.
Go ahead, say that one more time. That's so important.
You want to find an attorney that concentrates in tax and estate planning. Why? Because those things are interrelated. If you go to an attorney, and I'm not saying that they're incompetent in any way, that's not their meaning for it, that does all kinds of things. Real estate, personal injury, criminal law, DUI, divorce.
No.
You don't want to go to that
You
attorney.
don't. And I see it all the time when generalists are trying to get into the area of estate planning, which is the most complicated area of the law. And you can just see, and I am not an attorney, but I can see that the documents are subpar. So what you're saying is really important. People have to know what they're doing in this area for sure.
Yes. And then there's websites that you can seek certain attorneys out on. Like there's one that I'm on. It's called AVO, www.avvo.com. And in your area, you can search estate planning attorneys and whatever else, but you have to read the reviews. The reviews tell you everything.
Yeah, I think so too.
And as a result, I don't know, I've got, I don't know how many reviews, but they're all 5-star reviews. You don't look at the AVO's grading of the attorney because from what I understand, if you don't pay them to advertise, you don't get a top score. So look at the reviews.
So they're
and the
not.
people's
So they're a
experiences.
marketing organization, is what they are.
Kind of, sort of, but
Oh,
it's
okay.
still a good. It's still a good place to go because there's lots and lots of attorneys. Like somebody had called me the other day. Hey, I need an attorney in Sarasota, Florida. I don't know any attorneys in Sarasota, Florida. Went on AVO, looked at a whole bunch of them, called a couple of them, said, you know what? I want you to talk to her. Called her, and hopefully they're doing a good job together.
Oh, that's good. So this has been very valuable. So let's wrap things up a little. But I want to make sure that our audience has a way to connect with you if they need estate planning. Of course, we will list all of your contact information in the show notes for those of you that might be listening while you're driving. So, Bob, what's the best way for somebody to reach you?
So my telephone number is, and it goes directly to me, is 630-215-3676.
One more
And
time.
then, pardon? 630-215-3676.
Perfect.
And I do have 2 offices. I have one in Downers Grove, and then I have another one in Itasca.
Okay.
Okay. And then my email is very simple. Lawmondo, all one word, LAWMONDO @gmail.com.
Perfect.
And then my website, which I post a lot of articles, pertinent articles on things or blogs, whatever you want to call it, is www.lawrjm.com. So lawrjm.com. And there's all kinds of information out there about everything kind of that we have discussed, trust funding and all kinds of different posts, a probate avoidance, the difference between a will and a trust, intentionally defective grantor trust, all kinds of things. And in the post, kind of what's going on today, I'll write an article about and post it out there. And some of it's is kind of interesting stuff about Prince. And I'm going to write one now about Robert Redford because he just passed away, and Rupert Murdoch, and all kinds of different things that are kind of pertinent, that make it more interesting, and it's not just boring drivel tax work.
You know, Bob, I know you work with a lot of financial planners and you coordinate. Let's help the listener figure out how to pull their team together. Maybe they've never done financial planning or any legal work at all, and they're starting fresh. What do they need to be looking for?
Well, I always say that the first person that you should seek out is a financial planner, because the financial planner also has other team members that you can bring into the mix. So Chris, like you're our quarterback. So you bring me in. I'm a wide receiver or something along those, or a halfback or whatever. You're putting it in a football context. But then you also have mortgage people. If I ever need a mortgage, I know I can come to you. You can refer me to somebody. You also have accountants. So you've got a team of people. I don't have those people. You do, because you deal with that stuff on a day-to-day basis. Now, if you're looking for an attorney, I have a network of attorneys that I can refer you to. But I think it's first, most importantly, finding a financial planner. And I don't think that having less than a certain amount of money precludes anybody from finding a financial planner, because a financial planner
Good to hear.
does, and life insurance. Everybody virtually needs life insurance. People have 401ks. What happens when they leave their employment? They have to roll it over into an IRA, buying annuities. I mean, there's all kinds of things that you do, Chris, but you're the quarterback. You kind of direct.
You know,
tell us.
but I like hearing you say that someone should find, I would say, a fiduciary financial planner before going and seeking an attorney. So a lot of times people will approach me and say, well, we know we need to get this estate work done. And I say, thank you for reaching out to me first, because we'll be able to put some structure and guidance in place before you see the attorney, and it'll be very beneficial. So that's good to hear. So for our listeners, if you are interested in having a conversation about completing your own financial plan, I'm the kind of firm that looks at the good, the bad, and the ugly, and show you how estate planning can fit in with everything else that you need to do to have a successful financial plan. So we are the dynamic duo, right, Bob?
That's right.
We are. Okay. Any final thoughts at all for our audience?
One thing you do is you just have to be cognizant of the fact that we all can't do it by ourselves. We need help. It's true.
Wisdom. Folks, that's Robert J. Mondo, attorney and estate planning expert. And you can find more information about Bob's practice at lawrjm.com. That's lawrjm.com. Thanks for joining us today on Beyond the Numbers. We'll see you the next time. Be blessed.
Thank you.
Absolutely.
Beyond the Numbers podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.